like that. Really, I heard or read the story probably like everybody else did in the various media outlets, and whoever here, I'm sure we read it in your media outlet, and your media outlet was the first one I read it in. But, because that's the one I look at first every day. And so, Mr. Strang had a sold-out event at, I believe it's Sisyphus Brewing tonight, over in Minneapolis to talk about this, and obviously this is something that this series I got enthralled with, Representative Zerwas got enthralled with, and many of us did. I want to make it clear that obviously, people, Mr. Avery was convicted. We're not here to revisit whether he necessarily should have been or shouldn't have. My perspective comes from the area of law enforcement and a policymaker combined, where I saw things in that documentary that were concerning to me in law enforcement, and Nick also has a background in law enforcement, working as a crime lab person in the Manitowoc County Sheriff's Department, and has family in the business. And it really is, in this day and time, it's my goal that, we do as much community outreach to make sure people know that, we're providing a fair and just service from law enforcement to prosecution, defense, and at the bench, that our system was designed, and I was taught this when I was going through college for law enforcement. Please join us, Representative Atkins. This is very, very informal.
So I'm going to another meeting.
Okay, all right. Joe Atkins, ladies and gentlemen. But
Joe Muller is up there.
Is he? Yeah. So really what it comes down to is I was taught, and I fully believe, that our system was designed to let 100 guilty people go free before one innocent person lost their freedom. And we are 100% committed to making sure that guilty people get the justice that should be served to them, as well as victims and the innocent. So with that, what I asked Mr. Strang was, while you're here, was just to kind of revisit some of the things that certainly could have been done better. And in my education, some of the best lessons I learned, especially on how to do things the right way, came from defense attorneys, because every defense attorney I worked with, usually in opposition, obviously, really did want to make sure I did my job better, because they did not want guilty people walking free either. And so I have great respect and great admiration for the profession. And so, I said, have you ever thought about what policy changes or what guidelines? And I've also thought, the first time in my department, or any department, when we have an issue, we go back over guidelines or policies. And so, for instance, in the first case, when they found exculpatory evidence, so he did not commit that rape, then was there any policy changes within the Sheriff's Department about how they handle and conduct investigations, or as it moved forward? Because I can assure you, in ours, there would be a review that says, hey, if this comes up, here's the new guideline, you're not doing that. So, without further ado, I really want to thank you for taking the time. We are going to be probably, we'll try to cut it short a little bit, maybe at 2:50 if people at least want to shake your hand and visit just a minute. But Mr. Strang and Representative Zerwas and I absolutely got to be in a car at 3 o'clock in 10 seconds. And Mr. Strang has other things he has to get to as well. So without further ado, thank you so much. And Dean Strang.
Well, thank you. I really do, if you'll bear with me, I want to spend a few seconds thanking both Representative Schoen and Representative Zerwas and everybody else here. I'm a Badger, and that's not why I'm thanking you.
And Representative Khan is flying the colors today. So be careful.
Representative Khan and Senator Dibble and all the other lawmakers and staff and friends here. I say that only because, not to rub your nose in the fact that I'm from the state to the east, but because it's hard for me to imagine right now in my own state a bipartisan sort of conversation like this happening right now, just to be blunt, at least happening in the same way. And I want to thank you for making this a nonpartisan issue and inviting me in for a conversation. I really do. I appreciate that very, very much. And it's good to be here. I don't know, this was intended to be a conversation. I don't want to hold a monologue.
We certainly have time for you to do a little bit of that.
No, don't give a lawyer a microphone like that.
It's better than giving a House member a microphone.
Sergeant at Arms, Senator Dibble needs to be removed. Oh, sorry, was that out loud?
Someone's got to defend the Senate.
So tell me, how can I be helpful? What's useful and interesting to talk about?
I maybe start this off is based on some of the policy conversation, and one of the things that what did you see change, or maybe there was none, and would you? And what would be your recommendations? I can say that Representative Zerwas and I talked about a few things related to the second incident, and if that happened to be agencies that we worked in, how it would have been handled. And maybe you could touch on a little bit of that, about that starting even with the officers, and then what even guidelines as far as the defense attorney for the young gentleman as well, and the questioning, and how
Sure.
Was there any follow-up with that in Wisconsin? I realized that in the first case they had the Avery panel, or
Avery Commission.
Avery Commission to talk about making sure that innocent people weren't convicted and following up with that. But what was the result of, or if any, whether, again, policy, rulemaking, etc., from investigations, prosecution, defense, the bench, that people are looking at now and talking about?
Very little that I know. And maybe a good place to start is to talk a little bit about what you folks engaged in policymaking might be considering, whether formally as a legislative matter, or maybe informally because you've got a good perch from which to have conversations with law enforcement leaders. But I think that in general, law enforcement agencies have come a long way in the last 35 years. That's an arbitrary number, but roughly the last 35 years, come a long way in interjurisdictional cooperation, multi-jurisdictional task forces, or problem-oriented multi-jurisdictional groups. My own perception, and I'm sitting next to a police officer, but I, of course, have never been one, and I'm 2 generations removed from a police officer. My grandfather was a Duluth police officer for 30 years. But so I don't have any real personal understanding of policing, but my sense is that that interjurisdictional cooperation and coordination has not been as good, at least in Wisconsin, when the question is not collaboration, but a potential conflict of interest. Where for whatever reason, one department might have reason to question its own objectivity, or, just applying to itself the standard lawyers apply ethically, even if it's not a conflict. Is there a reasonable appearance of possible impropriety to an outsider? And I don't know that departments have thought through, as well as they might, how to anticipate those situations, because, they arise. The brother of the police chief is stopped for drunk driving after there's been, a car hit and a mailbox run over, and that's a minor sort of offense, relatively minor, hit and, run property damage, but with an overlay, let's say, of impaired driving. Well, that local police department, headed by the potential defendant's brother, probably ought to opt out of that investigation, even on a relatively minor offense. And if they've got to do that, what's in place? Do we simply call on the neighboring municipality and ask its police department? Do we call on the county sheriff if the offense occurred within a city or a village or some municipality? What do we do when we need to opt out by reason of appearance of conflict or actual conflict? That, I think, really is something that bears as much consideration as the efficiency to be gained by collaborating across jurisdictional lines. If many of you in the room probably have seen the documentary, in which I'm one of some dozens of people who appear, but one of the sort of core concerns that I had about that case in specific was the public was told repeatedly in the early days of the investigation into Teresa Halbach's absence, and then, an eventual a death investigation. The public was told repeatedly that the home sheriff's department would not be involved in the investigation, or would provide only logistical support. And that turned out not to be so. For whatever reason, the home county sheriff's department, in fact, recovered most of the significant physical evidence later used in the two trials that flowed from that investigation. And indeed, some of the very officers whose involvement was direct in the civil case that provided the occasion for reflecting on a conflict of interest were themselves directly involved in the investigation. I can't imagine that the two sheriff's departments involved there would do it that way again. Would tell the public one thing and then have that belied by the actual practice. I have no need to ascribe motives to anybody. I wasn't the decision maker. I'd be speculating, but just objectively, that wasn't handled ideally. If you were going to recuse yourself, you'd want to actually recuse yourself, I think, rather than look as if something was occurring under the surface, or that there was a lack of transparency and honesty with the public, whose attention was very much focused on a significant crime at the time. Senator?
Thank you. So, but is that enough just to have the investigation be handled by another agency? And the reason I ask is because, well, for a couple of reasons. One is, right here in Minnesota, we see a move now towards the state investigatory agency, the Bureau of Criminal Apprehension, taking on investigations of officer-involved shootings, and that's all kind of flowing from the disparity we have in how communities of color are feeling about how officers regard them. And in the documentary, I think it was your partner who was guessing that even the FBI probably was going to stand with their own in the lab results. And a county sheriff's department, was it just one county over, may still feel that affinity, that professional association that would cause them to view things slightly differently.
And Senator, I don't know what the answers are, and they'd be different in every state. I think the main point is to try to anticipate some of these things as policymakers, and to think about both within law enforcement departments and as public officials ultimately responsible for the function of government, to be thinking about internal controls and how we handle these things when they arrive. You're absolutely right that while a conflicted law enforcement agency opting out of the investigation is certainly the right first step, then the next question is, well, all right, then who does do the investigation? And if we're concerned about at least the appearance of conflict or the appearance of impropriety, and we're going to the trouble and the inefficiency of removing the agency that naturally would investigate, then how do we, best minimize the appearance of impropriety we're trying to avoid, or the actual conflict we're trying to avoid? In very rural parts of a state, I think your intuition, at least I share your intuition, that the immediately adjoining sheriff's department is likely to have very close working relationships, relationships outside of work among members of the departments, and maybe that's not the best choice. Now, you've got to balance this against nimbleness. If somebody who's committed a violent crime is not apprehended on the loose, or if, you don't know if a victim is alive or dead. I mean, that obviously saving lives has to trump over almost anything, has to prevail over almost anything. But, if we now know that there's not an active risk, immediate risk to the public, how do we handle the investigation? And that requires, I think, anticipation in the same way and at the same level of careful planning that multi-jurisdictional cooperation requires. And again, I don't mean to be lecturing, and it would be fatuous of me to do that, but
everyone else does.
Well, they don't. I mean,
that's what this room is for.
I think that I want to be very careful of not suggesting that I would import, or that anybody should import, a corporate model to public agencies or public functions. Okay, so with that preface or caveat, I do think that among the assemblage of institutions that together compose our criminal justice system, we probably could do more thinking about internal controls. Within each institution, whether that's the police agency, the prosecutorial agency, the public defender's office, the judiciary, whatever, probation, whatever it is, both internal controls within these agencies and across agencies. How do we use the one agency to make sure that we're minimizing the risk of harmful error, ultimately, the arrest or conviction of an innocent person, or this escape of a guilty one, falling, in the wrong place. And while, in a broad sort of 8th grade civics way, all of these institutions understand that they have separate roles and that they are, to some extent, checks and balances on one another. I don't know that there's really much fresh thinking along the lines of really how robust are our internal controls? How do we test them? What are the best practices in, establishing internal controls or outside audits of performance? So that's a long-winded way, I hope, of addressing your question, which is to say, of course, simply recusing a conflicted department isn't enough. But my point is really anticipating these situations, I think, is what law enforcement executives ought to be trying to do.
But to push back gently, doesn't this case look so different? And doesn't the defense look so much different? And doesn't everything change if, when the Manitowoc County Sheriff's Office says, we have a conflict, we will not be involved in the investigation, if they truly hand everything over to a state agency, or they truly hand everything over, even if it's a neighboring county, if those two Manitowoc deputies that have been deposed as a part of the civil litigation and a part of the identified conflict of interest, if they're never at the crime scene, if he's never radioing in the license plate, right. If those, I don't want to say suspects, but those folks that have been a part of the civil litigation, if they truly do identify a conflict of interest, remove the Manitowoc County Sheriff's Office from the investigation, doesn't a significant amount of that potential reasonable doubt, doesn't that get mitigated right off?
Oh, immensely, of course. I mean, you're most of the way there if you simply do what you say you're going to do, okay? I mean, that's you're most of the way there because, and we're seeing this all over the country now in the sort of chaotic, fractious, bumptious discussion that Americans have about police relations to communities. We're seeing that not only does getting the outcome right matter, of course that's the most important thing, but the perception of the public that you're doing the right thing in coming to the right outcome matters greatly. And so transparency, in every way you responsibly can offer transparency is the first step, and then honesty about what you're actually doing is the second step. And now it's just fine tuning, right? Let's not go to the next county over, the next village over. Let's bring in the state BCA, or let's bring in somebody from 50 miles away where there are not informal relationships among the officers involved, or whatever you do. But you're absolutely right.
That was, in fact, that was a conversation Nick and I have had about this several times from our background. I mean, we both worked in I work in, he did, in a department that, all but 3 in the state of Minnesota until recently have the BCA come in and do officer-involved shootings. And I said, I can't imagine in my department, or and many of his family members, our extended family members, our law enforcement and various agencies around the state, and the ones that I know, I'm like, that, if that same exact scenario were to take place in my agency, that address pops up, they'd be like, yeah, no, have the county come in and take the call and see who's close, at least even the call to the house. But once you realize that it's not an emergency situation, it'd be, we got to lock this down, and we're not going to have any hands in this. And this particular scenario would have been, for our department, and most in Minnesota, would have been the Bureau of Criminal Apprehension coming in to do that, and seeing that conflict if they needed any other help. then that would have been either the county or another agency that they would have brought in. And that is something that has happened in Minnesota without a regulatory effort. That has just been one of those things that's probably been over time, seeing that we don't, and that is exactly part of the conversation today, is we really want to be in a space where, the people of Minnesota look at us and go, yeah, we got the right things going in the right direction, and we should never be afraid to look for improvements. And that's the biggest key.
Well, right, and let's pick up on something else that you've touched on already, and that I've sort of grouped under the loose heading of internal controls. Again, as policymakers, I'd be thinking about this. In healthcare, most states, by statute, have created some space within which hospitals, medical clinics can conduct critical incident reviews after the fact, where they've had a bad outcome. There's evidentiary rules now in many states that, as I say, create a space for the administrators of the hospital to take an honest look at what went wrong without worrying that by doing so they're creating civil liability or generating documents that are going to be used against them later in a malpractice action or whatever it is. And I think that sort of critical incident review idea is enormously useful in healthcare at anticipating the next problem or correcting honestly whatever the flaws or failings systemically were that led to a bad medical outcome at a hospital. And I'd like to see police agencies have the same sort of room to do that, and prosecutors' offices have the same space to do that, and to recognize mistaken convictions or even convictions that may be right on the merits, but that were arrived at by Fourth Amendment violations or, at least practices that didn't follow departmental rules. Have them be able to recognize those kinds of things as critical incidents. It's not just, how did we handle an active shooter in the community, or how did we handle, a flood or a levee breaking, that sort of critical incident. But what about a bad outcome in court or, an inappropriate use of police resources? Can we recognize that as a critical incident and review it without being worried about blame placing as a first concern, or liability as a first concern? If I have a broader theme to offer, it is that we need more humility in all of our criminal justice institutions and functions, and that we ought to be more worried about correcting mistakes when they occur, preventing them the next time, and less worried about assigning blame for the mistakes.
Anytime we can get a lawyer to come here and talk about lowering liability, well, it doesn't happen that often.
No, and look, there's a place for accountability, right? But it seems to me that accountability has to come after we've diagnosed, acknowledged, and tried to prevent a future recurrence of the same mistake.
And to do it quicker. In the healthcare world, you can do these almost immediately or in a very short amount of time. As a paramedic, we did this regularly, and you could teleconference these things too with a bunch of different people and be able to actually talk about the incident and say, yeah, this didn't go as well as it should have, or this would have been better, and not have to wait until a civil suit was over if there was one in the first place. I mean, we could do this without even knowing that there maybe would be or wouldn't be.
Yeah, and civil suits, again, accountability has obviously is important in the long run, but civil suits are such a lousy mechanism for really reviewing honestly and quickly and efficiently what went wrong and what do we do to prevent that from recurring. They're just a bad mechanism.
And those reviews did not, stand in the way of a civil suit. If a person or family member wanted to bring one, that was all internal, just to make sure we were.
And that's fine, but I think the trade-off of taking off the table as potential evidence in a civil suit the outcome or the review process is a pretty good public trade-off, to my mind, because these reviews don't happen honestly. They become themselves political exercises or exercises in covering your rear end if they're conducted in the glare of or under the constant threat of liability and blame being assigned as a product of the review process itself. I don't know if I'm being very clear about that.
No,
but,
Sheldon. Representative Johnson.
Yes, sir. To what extent, this is kind of a different question, but to what extent did the documentary give a slanted perspective of the crimes committed? I assume the documentary kept some information in and left some information out, and now I see the prosecuting attorney is going to write his own book with his interpretation. So what do you make of that? Is it a perspective the documentary provided, and do we need another perspective from the prosecutor to lay out his story?
Well, I think, at some level, any number of perspectives on this one trial or these two trials are fine. Terrific. The more, the better. But my frustration with that is simply that we not get lost playing second-string jurors after the fact or armchair sleuths on two cases that are already 8.5 years old. The value to me of the documentary or of any book about the case ought to be asking bigger questions about the system and the reliability of the outcomes we achieve in our criminal justice system. So I welcome any additional perspective, book, film, interview, whatever. That's all great on these two cases, but it's not really where I think the public focus ought to be. In terms of this documentary itself, I'm obviously not a filmmaker. I don't know the first thing about it, but this film was a little over 10 hours long, right? That's a long time, even when you break it up into roughly hour-long segments or episodes. And what we're seeing here, not just with this film, but with a lot of entertainment now, is it's not a different genre, but very rapidly we're developing different ways of consuming entertainment. You don't have to wait till next Wednesday night to see the next episode of your favorite show anymore. If you do nothing, Netflix just starts it for you in 20 seconds, right?
And there are a lot of people in this room that didn't shower or sleep for a couple days.
So
I'm looking over that direction.
No, just think.
I only watch one at a time.
But just think of how different that method of consumption of entertainment is than it would have been even 20 years ago. And so now you've got a 10-hour film, okay? more than 3 hours of that 10 hours were devoted to this one trial in which I had a front row seat, the Avery trial. Another hour plus devoted to the Dassey trial, okay? That's a lot of time. Just the 3 hours on the trial itself, the trial proper, in the Avery case, that's one trial in one county in one state, and it got the same amount of time that Dr. Zhivago gave to cover the entire Russian Revolution, a little over 3 hours, an epic movie like that. But even with that generous amount of film devoted to that one trial, you're still talking about a trial that had over 200 hours of evidence over the course of 6+ weeks. And you may binge watch a 10-hour film. I don't think you're going to binge watch a 220-hour film. I hope you're not. So
We're legislating.
So
We're weird.
To me, it's kind of a dead-end conversation, really, to talk about what got put in and what got left out. Look, films are made by human beings. Every human being has a point of view. Every human being's point of view would be a little different than the next human being's point of view. And, if Sheldon Johnson were making that film, you would have made different editorial decisions than these two filmmakers. I would have made different editorial decisions still. Danny Schoen would have made yet different editorial decisions. So, maybe the profusion of the viewpoints is the answer to all of that. But there again, I think, we sort of get lost in the weeds on two cases. And yeah, they're compelling little stories. But in the end, other than to the people directly involved, they are small stories. And let me put it this way, those are two cases that were tried in 2007. In 2007, about 20 million criminal cases were filed across this country. About 12 million arrests were made of Americans on the streets of the United States in 2007 or any year after. And, wherever the Ramsey County Courthouse is, there's hundreds of people going through court today there. And I think it really behooves us to be thinking about broader questions and worrying a little bit less about the specific outcome in a given case.
I got to give Representative Moline, who's watching it, I believe through Upstream, or Uptake, and I want to thank those folks. But so here, Representative Moline up on the Iron Range, Hibbing, Minnesota. She couldn't make it down, but wanted to.
She's an attorney herself.
She is an attorney herself, and she's awesome. So, are you aware of any newly discovered evidence that allows Mr. Avery to get back in the courtroom? That's one. Also, do you know the status of Mr. Dassey's habeas corpus petition in federal court? And then, we'll go with those two.
Okay. One of the functions, again, of this change in the way we're consuming media content is that Jerry Buting and I assume Brendan Dassey's lawyers and Steven Avery's new lawyers are being barraged with ideas, leads.
We got Facebook and Twitter, too.
Right. I'm told that Reddit has, demonstrative exhibits and timelines and all kinds of things out there. So you're harnessing the minds of probably millions of people in looking anew at all this. Now, how much of that new information or new ways of looking at old information or new ideas about scientific advances, how much, if any of that, ultimately would be the sort of new evidence that might support a new trial, I have no idea. And just sifting through and setting priorities on what of those ideas to pursue and what not, or in what order, is itself a massive task. So, that task won't fall to me, primarily because, I'm not Steven Avery's lawyer anymore, but, I am passing along what I've gotten to his current lawyers and to Brendan Dassey's. Brendan Dassey, unlike Steven Avery, still is in federal court. As the representative points out, it has a habeas action pending in federal court. That, I think, has been fully briefed and is awaiting decision by a judge in Milwaukee. And I have no idea, nobody would have any idea what the time frame would be on a decision there.
Is anybody over here? You guys have anything? Before, because I know we're getting down, and I know you and then Senator Dibble.
Getting back to the broader scale for a moment, one of the things I think, being a former sheriff's office employee and going through several trials and then watching the documentary, what becomes pretty apparent in not difference of outcomes in this instance, but difference in representation, looks at a suspect that has been charged and can afford a very good, a very expensive, good private attorney versus a criminal suspect, criminal defendant that is getting a court-appointed lawyer. And I don't mean to slight public defenders or the public defense system at all. With the limited resources that they have, they put their heart and soul into their cases. But I'm wondering, with your experience, and I think it's kind of magnified in the program as well, but what does that say about our criminal justice system in the broader sense, about a defense you can buy versus a defense that can be provided for you?
What it says a lot, and most of what it says isn't very good. Let's talk specifically about that. As by way of segue, in tough budgetary times and in times where the public is very resistant to tax increases, it can be a hard sell to increase funding of the BCA or the Attorney General's office or, sort of the prosecution and policing apparatus. That can be a tough sell, right? Well, now try selling increasing public funding for the defense, which is widely viewed as just using tax dollars to make lawyers rich and give bad guys lawyers. That's a tough sell for elected officials. I want to suggest that the courageous and thoughtful members of the public and public officials will recognize funding the defense as a public good. As something that should increase our confidence as members of the public in the outcomes that our courts produce, especially where, we're the developed nation with the highest rate of incarceration, we're the developed nation with the longest mean sentences. Okay, we hand out time like crazy. We're the last developed country, developed democracy, at least in the world, still to use the death penalty in many states. 31 states still have that, and the federal government has that. So, at a minimum, I think we're entitled to maximal confidence in outcomes, and that means funding the defense in practical terms. Upwards of 90% of people charged with crimes in Minnesota or in any state in this country can't afford to hire a lawyer. Upward of 90%. And for the thin percentage who can come hire Dean Strang or somebody like me, look, I've got a caseload of 30 cases open at any given time. Okay, now some of those are appeals and they're in different courts, so I have some inefficiency because I may be traveling a long distance just to get to a short court appearance. All right, I don't have the efficiencies of a public defender, but I've got 30 open cases tops at any given time. In my state, a public defender or somebody who's by and large subsisting on court appointments will have 150 or 200 open cases. And they got the same 24 hours in the day I do. You know, they don't get 48 hours in the day to deal with their caseload. So, you know, you simply do the math on what sort of attention the best intended, most altruistic public defender or court-appointed lawyer can give to clients. Her time is spread out across 150 people. My time is spread out across 30. And by the way, most of my clients aren't in jail before trial. They can come to my office to meet me. If I'm a public defender in Anoka County or something, many of my clients are held in jail pending trial for want of $500 to post bail or whatever it is. And now I've got to go to the jail. And that's not an optimal place either for efficient use of time or for meaningful development of an attorney-client relationship. So, you know, the underfunding of the defense function is chronic in this country for perfectly predictable and understandable political reasons. Again, it looks like you're simply giving money to trial lawyers and benefiting bad guys. But if at the end of the day we want to have confidence that we're getting it right, the fact of the matter is that we've got to fund indigent defense because our courts live on indigent defendants. There's almost no one else who passes through them.
Well, that got a response back there. That's good. Senator Dibble. So,
We'd gavel that applause down in the Senate.
yeah, right. Well, we're not in an official meeting, so you can cheer and do the wave or whatever.
Yeah.
So we're running short on time, and Senator Dibble, I'll give you the last question
all right.
before I
Well,
ask the final burgeoning question.
Oh, it's kind of a big question, and this is so we covered a little bit of ground on, you know, maybe some of the structural, systemic policy and/or individual failings of the sheriff/police investigation, but much of that was ratified, you know, by how the prosecution handled the case, by how the court received a lot of that, and how they regarded it. And you know, I'm reluctant as a legislator to violate the separation of powers or get into the business of, you know, the rules of judicial rules of criminal procedure. But you know, watching the, you know, I want to say I don't know if Steven Avery is guilty or not, or Brendan Dass is guilty or not. I have a perspective because of the documentary, but I can't possibly know. But certainly things happened that made me nutty that I want to do something about because I'm a legislator. That's what we do. I'm trying to figure out where though would legislative policy interventions be appropriate, and some of that stuff that we saw that occurred then, and how the prosecution was handled and how the bench handled.
And maybe if you
it.
had just a quick top three, if you've ever thought about it, to keep you on track here. So I got the question that everybody wants to answer to when we're done with this.
Okay. It is a tricky area with separation of powers, but maybe legislators could start a conversation about standards of review in the courts by bringing the insights of, say, behavioral psychology to the rather dry topic of standards of review. The fact of the matter is that on appeal, from a behavioral psychologist standpoint, confirmation bias is built into the appellate process at every step. The inclination that the system is rigged to ratify what has gone on below, in the court below. Whether it's an abuse of discretion standard, a clear error standard, a plain error standard, or de novo review, but then with the backstop of harmless error to excuse a mistake, an error. This isn't to suggest that courts ought to be reversing every conviction for every technical error. I mean, but it is, you know, that's how courts were perceived in the first decade or two of the 20th century, And with the legal realist movement, an effort was made to sort of adopt harmless error doctrines and to get away from, highly technical, mechanical reversals, which carry great social costs and cost to victims when cases have to be retried. But it might be time to re-examine whether we've swung too far in our bias in favor of confirming what went below. One thing, too, you can do as legislators is think hard about reducing the penalties altogether. And looking for alternatives to incarceration. We're always going to have an imperfect system. We're going to make mistakes. We're human. Everybody in the system is human. There are going to be mistaken outcomes. Legislators are in a good position to at least make the individual harms of those mistaken outcomes less than they might be. If I'm mistakenly convicted, thank you, I'd rather do 5 years in prison than a mandatory minimum 10. If the courts aren't going to do anything to correct the mistake. You also, finally, third thing, you might be in a position to start prodding the executive branch, you in Minnesota and everywhere else, start prodding the executive branch about reviving clemency. Executive clemency has died on the vine in this country since 1976. It has plummeted. And you hear governors who often now don't view a governorship as a terminal political office. You hear governors saying, well, it's the court's responsibility, or the courts have looked at this. I'm not going to commute a sentence or pardon somebody. That's for the courts. No, actually, Governor, that's for you. That's an executive power, and the failure to use it responsibly, or the failure to at least consider using the clemency power responsibly, I think undermines or forfeits some of the dignity of the executive office. And you folks in the legislative branch are in a pretty good position to start making some noise like that, because clemency, pardons, commutations used to be very common in this country, and the republic didn't collapse. What has collapsed is that essential mercy and that backstop against errors that courts don't create. That's what's collapsed since 1976, roughly, in this country. So those might be my top three.
Well then, finally, I showed you, so now we're going to get, we won't get into policy. So Kristen Bell, I showed you the tweet from Kristen Bell that's made thousands upon thousands. And so I hope Kristen Bell is watching. If you want to hang out with the three of us, everybody at the table, we'll all love to hang out or something. But anyway, so we're going to tweet at Kristen Bell later how we got to hang out with you. But all right, what's life like for the Dean Strang, and family right now?
It's different. It's different than it was at Thanksgiving. If you're kind of a short, unobtrusive white guy living in Wisconsin, you mostly don't have to worry that you're going to wind up in a room of 100 people in Minnesota talking legislative policy. So it's been a strange ride. It will end quickly, just because I think probably most of the people who will ever see this film have seen it by now, and there is no sequel involving Dean Strang, at least. But it's been strange. It's given my wife Janae endless cause for hilarity, teasing me, and that's all good. and my dog misses me at least, so.
Well, I can't thank you enough for taking the time. I called you out of the blue, and I mean, I was just like, I said I'd be remiss if I didn't ask, but I understand that you probably don't have but 5 minutes to even take care of yourself at this point in time. And he's like, I'd love to. And this is a great amount of respect that we have for you to take the time to come in. And again, varying opinions certainly circulating, and it has been my goal since I've been in the legislature and as a police officer, just even to show that, the public process, or the process, whether it's in the justice system or in the legislature as a whole, where it needs to be open, it should be open. I wanted to get that out there, like the data piece for Mary Liz, to make sure we have open and clear government and respectful. And I think that is the biggest piece, is that, as police officers, attorneys, and judges in the justice system, particularly, we have a great amount of responsibility to carry that torch, and we have that here in the legislature as well, too, to make sure that people do trust what happens, and that when we can demonstrate that and show it, we should. And we should always never be afraid to say, well, we shouldn't always, what I always have difficulty with is somebody says, well, that's the way we've always done it. Well, should we continue to do it that way? Maybe there's a better way. And it should be okay to talk about that. And if we can't find a better way, then at least we know. And we tried. And I really appreciate your time. And I thank you, everybody that came in. And I'm sorry we didn't have more time. But we're going to end the meeting here. Thank you so much.
Thank you for having me.
Do it. Oh, we'll get moving.